Okay, I think we're going to go ahead and get started with today's webinar. Thank you. Welcome to everyone joining. This is the first webinar of MOVA's Victim Rights Month webinar series. My name is Lisa McHugh, and I'm the Director of External Engagement at the Mass Office for Victim Assistance. I'll be introducing the presenters shortly. Before we begin, I want to share some helpful information. We are providing ASL interpretation and CART captioning for today's session. To view captions for this presentation, click on Show Captions at the bottom of your Zoom screen. And if you would like to view CART interpretation in a separate window, please click the CART stream link provided in the chat. If you are having trouble seeing the ASL interpreters or captions, please message all panelists in the chat and use the Q&A function, not the chat, to submit questions for the presenter. I'll be monitoring that for you. We also recognize that the content today may bring up difficult feelings. Please take care of yourself in whatever way you need. As a reminder, this is a webinar format, so attendees are not visible to the presenter or audience, and your audio is not enabled as an attendee. It's my pleasure to introduce today's presenters. Attorney Aimee Parco from Greater Boston Legal Services, Attorney Ann Sheldon from the Massachusetts Law Reform Institute, and Carmen Aliber from Together Rising Above Coercion. This webinar will provide a detailed overview of the new law, including what coercive control is and how it is defined under statute. Presenters will review relevant case law and share practical guidance for advocates and survivors preparing for a 209A hearing. More than a year into the law's implementation, there are still open questions, but there is also emerging case law and courtroom experience that can help inform advocacy. The presenters will share updates based on their work representing survivors and supporting advocates navigating this new legal framework. And now I'd like to turn it over to Aimee, Carmen, and Ann. Thank you so much for being here.
Thank you so much for having us, and thank you to everyone here in the audience for your interest in the subject matter. I think just before we get started, I just want to mention that we're interested in hearing from you all about what you're seeing with regard to the new law. We're also interested, I don't know if it's easier to put it in the chat, like just put a yes or anything if you were here or watched the training we did on this last year. It's mostly for my benefit, so I can know how quickly to go through some of the slides that are repeats. So if you were here last year, if you don't mind somehow indicating that, that would be really helpful. So at this point, I'm going to pass it on over to Carmen.
Sounds great. Thank you so much. Good afternoon, everyone. Thank you for being here. I'm Carmen Aliber, and today I join you to share my story and hopefully shatter the stereotype of what a domestic abuse survivor looks like. In 2019, I had a family, a home, a career, savings, and a distorted definition and image of what domestic abuse looks like. I used to think it would never happen to me until I found out it could, and it did. I quickly discovered that domestic abuse does not start with bruises, blood, and broken bones. Rather, that's where it leads when we fail to recognize the patterns of coercive control, which is the foundation of domestic abuse. Unaware of the tactics or the term coercive control, which I had never heard of, I fell prey to a predator who stole my innocence. He shattered my confidence, and he isolated me from my support system, then coerced me into applying for a marriage license just hours after I received an unexpected cancer diagnosis. Days later, after the requisite waiting period in Massachusetts, we were married. The next day, I began cancer treatment. 5 weeks into that fateful marriage, the abuse began, starting with an unimaginable control, psychological manipulation, financial demands, including his expectation that as his wife, I would now be responsible for using my savings to pay for his child's college tuition. When all else failed, he used threats of divorce to control me. He preyed on me at my weakest when I was dealing with cancer and then recovering from surgery. 6 months into the marriage, COVID hit. I was quarantined with this abuser who felt empowered to control my clothes, my hairstyle, the way I spoke, the tone of my voice, my bedtime, my diet, and my weight, or as he liked to call it, my shape. His subtle takeover of my life, veiled as his desire to help me live and look better, quickly morphed into an insidious pattern of manipulation known as coercive control. I found myself living a nightmare behind closed doors as my world closed in. I was the target of his emotional, psychological, financial, technological, legal, and other forms of abuse that to this day, 5 years later, are still too personal for me to share. So why didn't I leave him? It's a question people often ask me. And it's a question that many ask survivors. Some have children, and that makes it difficult to leave. Others lack financial resources. Still others stay for religious or maybe cultural reasons. Me? Why did I stay? I was paralyzed. I was paralyzed and silenced by shame and stigma. I had sold my home of 30 years and left a community in which I was a public servant for 6 years. I was ashamed and thought I had no place to go, so I stayed. I stayed trapped behind those closed doors. Given my professional career, which I had spent decades building, I was determined to hide the truth of what was going on in my home. If it meant I had to hide it and hide the truth to protect myself for survival, that's what I was going to do. As a mother, I also did everything in my power to protect my adult children from my abuser, who threatened to disrupt their lives and their careers. Acquiescing to his demands felt a whole lot safer to me than enduring the consequences of the threats he made against me and my support system. I was afraid and manipulated by his control. I drained my savings to assume his mountain of debt, a form of abuse known as coerced debt. When his psychological and verbal abuse became too much for me to bear, I retreated like a child in a fetal position, begging him not to hurt me. One night, cowering under a blanket and feeling the heat of his raging breath on the other side of that fabric is a memory I will never, ever forget. That comes second only to the chill of sleeping in my car at a highway rest stop one cold November night, because it was the only place I knew to seek refuge from his absence and his abuse. Behind those closed doors, this cycle continued for 21 months until I finally found the courage to walk out and file to divorce. I left him, but his abuse continued. Post-separation, my abuser continued to send me ominous messages, including a warning that he had others monitoring me, his words, on his behalf, which is known as proxy stalking. He worked in cybersecurity, and he refused to give up any control of me. He refused to release me from his E-ZPass account, which allowed him to track my whereabouts, and it prevented me from getting my own transponder in my own car. because he controlled the transponder that was assigned to my license plate number. He continued to send random and chilling text to me, my friends, my family, my neighbors, even domestic abuse colleagues, allies, and advocates. The day after Christmas, 5 months after leaving him, he sent a random but chilling text message that read, "How long does Carmen have to live?" More legal intervention was required to combat this pattern and his tactics to control me from afar. A forensic investigation revealed that he took control and locked me out of my personal email account. He erased my addresses. Without my knowledge or consent, he had linked his devices, my devices, I should say, to his, which allowed him to track my emails, my phone calls, my texts, my photos, anything that I did through my phone, he could track, all at a time when I was trying to leave him. More legal intervention followed when I discovered he was in the final stages of refinancing our jointly owned home, again, without my knowledge or consent. While this pattern of abuse qualified me for the state's address confidentiality program, it did not qualify me at the time, 2021, for a 209A protective order. That is what led me to help change a law. I was determined to protect others so nobody else has to go through this. On June 2023, a year after my divorce was finalized, I broke my silence and I shared my story for the first time publicly as part of a legislative briefing on Beacon Hill to support a new law to protect survivors of coercive control. Exactly 1 year to the day later, on June 20th, 2024, Governor Maura Healey signed into law House Bill 4744, an act to prevent abuse and exploitation. Next slide, please. As the founding member of TRAC, Together Rising Above Coercion, a statewide grassroots coalition of abuse survivors, advocates, and allies, I know firsthand the devastating effects that coercive control has on victims, on survivors, their families, and our society. Today, we have the vocabulary and we now have this law in place to protect others from coercive control, which again is the foundation of domestic abuse. On behalf of survivors everywhere, I thank you for being here today to learn more about this coercive control law and how you can use it to protect yourself and others. Because working together, we can and we will help others rise above coercion. Thank you for being here.
So thank you so much, Carmen, for sharing your story and your really inspiring advocacy. I think this next slide we'll just go through very quickly. It's the examples of coercive behavior. As I think Carmen touched on many of these in the context of her story. But you see acts of isolation, restricting access to basic needs, monitoring, and financial abuse. Again, I see a bunch of folks have attended the past hearings or the past trainings, and so I don't want to go over some of these in too much detail, but should you have more questions, please add them in the chat or we can talk about them at the end. Some other examples of coercive control that Carmen spoke to, it's restricting autonomy, psychological abuse, so verbal abuse, gaslighting, emotional blackmail, sexual reproductive abuse, so interfering with birth control, coerced sexual contact, intimidation and threats, and then legal abuse. We'll go through these examples again in a minute when I go through the language of the statute, but we just wanted to start with that. All right. So as Carmen mentioned, 209A, the definition of abuse in 209A was amended to include coercive control, which I really like that description that Carmen touched on, how it's the foundation of domestic violence. One thing I'm very excited about this law is I think not only does it provide legal remedies for folks experiencing abuse, but it's also a tool to help the community and the bench have a deeper understanding of what domestic violence is. And as Carmen shared, with coercive control at its foundation. So I'm just going to read you the language of the statute right now, the language that was added, not the whole thing. It's long. And then we'll go on to talk about what's happened since last year, some cases, not very many, and then also the restraining order guidelines and what guidance they provide on this new law. So it is a pattern of behavior intended to threaten, intimidate, harass, isolate, control, coerce, or compel compliance of a family or household member that causes that family or household member to reasonably fear physical harm or have a reduced sense of physical safety or autonomy. And then it goes including but not limited to. But before I move on to the next slide, I just want to point out a couple of the things in this. One is the behavior is intended, right? So you have to show intent. I'm highlighting that because it's something that will come up in a little bit when we talk about the restraining order guidelines. So you need cause and effect. So it actually has to, that behavior has to cause the family or household member to reasonably fear physical harm, which is the language, the previous language from other definitions of abuse under the statute, or have a reduced sense of physical safety or autonomy. And you might say, what does that mean? We're still working on figuring out exactly what that means, but again, we'll touch on it a little bit later on as the guidelines touch on it. The one thing I just wanted to flag here really quickly is you see family or household member. For folks not familiar, Chapter 209A has a very broad definition of family or household member. So it includes somebody in a substantial dating relationship, like an ex-sister-in-law would count, things like that. It's a very broad definition, although it says family or household member. Another training for another day, but if you have interest in that, you go to the language of the statute and we'll have the definition of family or household member there. Okay, so continued. So the last slide, remember I left off at, so there's this pattern of behavior that's including but not limited to. So these are all examples in the statute that talk about what coercive control could be. So it's including but not limited to. So one example, so I highlight that because this isn't an exhaustive list. These are just some examples to help guide plaintiffs, advocates, judges to understand what coercive control is. One example that I think doesn't come up in this list, that I think there are contexts in which it certainly applies as coercive control, is immigration abuse. There are certainly other examples. That's just the first one that comes to mind for me right now. So again, included but not limited to, but this is a pretty good list to go off on. Okay, so I'm going to go through it a little more quickly than I did last time because we've gone over this again. We've gone over this before, but again, at the end, questions. So isolating the family or household member from friends, relatives, or other sources of support. Depriving the family or household member of basic needs. So this could be cutting off the utilities, stopping paying for the mortgage. Example of isolation I think about a lot is a former client once shared with me, my life got so small. And so I think that's a way for an advocate to think about isolation, right? It's about isolating somebody truly and preventing them from having access to support outside of their abusive relationship. Controlling, regulating, or monitoring the family or household members' activities, communications, movements, finances, economic resources, or access to services, including through technological means. I don't think I need to go into this one very much. I'm sure everyone here who's worked with survivors or is familiar with this. I know Carmen spoke to this with her Easy Pass, as well as other ways in which her abuser monitored her. the examples continue. Compelling your family or household member to abstain from or engage in specific behavior activity, including in criminal activity. One example I think about from my previous work, but I think there are lots of examples of this, could be, my clients who were compelled by their abuser to engage in, sex work or other things, dealing drugs came up too. Threatening to harm a child or relative of the family or household member. Folks familiar with high-risk indicators know that harm, a child that is not the child of the abuser in the home is an indicator of high risk. So I'm grateful that this language made it into the statute, and we'll touch on it again a little bit. Committing cruelty or abuse of an animal connected to the family or household member. Again, another reference to folks who are familiar with the high-risk indicators. Cruelty or abuse towards an animal is certainly one. Intentionally damaging property belonging to the family or household member. I'm so glad this made it in. I can't tell you how many times before the change in the law, right? I'm sure anyone here who works with survivors has seen property damage fit into the pattern of coercive control and coerced and abuse, but not necessarily fit under the old definition under 209A. Threatening to publish sexually sensitive personal information relating to the family or household member, including sexually explicit images. For context, this was part of a big bill called an Act to Prevent Abuse and Exploitation. And in that was also a lot of additional protections around explicit image abuse. And so this ties it together, I think, to that. Using repeated court actions found by court not to be warranted by existing law in good faith argument. So this is a tricky one. The guidance I've received thus far, and again, this is all new, so I welcome thoughts, is that sometimes you see what's called a gatekeeper, where the judge basically says you can't file, tells an abuser who files copious somebody who files a lot of litigation, that you can't file without permission from the court. So that could be a good example. A gatekeeper action might help you if you have say if there's a gatekeeper in the probate and family court case, that may help you fit under this pattern. But time will tell. All right. So that is the way to think about this, and we have a slide in a minute, is the new language says a pattern of, including but not limited to, and then all of those things I went through. So you could show a pattern. And what is a pattern? Just you wait, we'll get right to that. But first, I want to finish the language of the statute, which I think is important because I'm not sure if it made it into the slides, but there was a recently unpublished decision that the appeals court wrote that only quoted the first part of the statute, not the second part. So we have to cover the whole thing because we all have to read the whole thing because it may or may not apply to your circumstance, your client's circumstance. So that is a pattern. What is a pattern? We'll get to it. Or a single act. So I don't know if folks here are familiar with harassment prevention orders. It has a similar language, right? You can either satisfy it through specific single acts or a pattern. That's what this is here. So if you meet one of these single acts, you don't need to show a pattern, okay? Whether or not if you also have that pattern is worth bringing up. That's a litigation question. I think, in my opinion, it very well may be worth bringing it up. The pattern as well as the single act, but case by case. So it's a single act intended to threaten, intimidate, harass, isolate, control, coerce, or compel compliance of a family or household member that causes the family or household member to reasonably fear physical harm or have a reduced sense of physical safety or autonomy. Again, reduced sense of physical safety or autonomy, what does that mean? We'll get back to it. So these are the single acts. There are 3 of them. They only need one of, not a pattern. Harming or attempting to harm a child or relative of the family or household member. Committing or attempting to commit abuse to another animal connected to the family or household member. Or 3, publishing or attempting to publish sexually explicit images of the family or household member. So these are the 3 that if you have 3 acts that if you have just one of them, technically under the statute, you should qualify for a restraining order. Again, it's a practice question about whether or not you'd want to mention everything else. And I think it's a comfort question for the survivor. Yes, I was about to go on a long tangent, but I'm gonna look at the time and not go on that tangent. But I would just say, if a survivor chooses to just focus on this one act because it may be re-traumatizing or difficult to tell the whole history, right? To make the case for a pattern. Because as we all know, survivors go, we ask a lot of survivors when it comes to providing protection or services in re-traumatizing folks and having them tell their trauma story again and again and again. So I'd just like to highlight, if relevant, that the restraining order guidelines, and I don't have the site on me, but email me, I'll get it for you, say that the judge is allowed to rely on things outside of the affidavit. So if the client just speaks to this one act in the affidavit, or you just speak to this one act, it doesn't mean that at the hearing you can't speak to other things if it seems like the judge needs a little bit more information. So just a reminder, just a practice point. And I wish I had that guidelines reference, but I just thought of it. Okay, so this is a visual graphic for the folks that are more visually compelled. Again, just to highlight, so you all understand it, that a pattern, you either need a pattern or you need one of the 3 specific acts. So the site in the statute is section 1DB. This. All right. So that is my very short overview of the language. Again, if folks have questions, they could drop on the chat or we could talk about it later. What we were asked to do today is talk about 1 year later, what's happened. And so I think I'm going to, so the short answer is not too much in the way of case law. But in October, or I think actually they weren't published, or they were published in October, but I didn't get access to them till February, and I don't know if anyone else did. There's the 209A guidelines, or the restraining order guidelines. I'm not sure if folks are familiar with these, but if you're working with survivors seeking restraining orders, I absolutely recommend you read these. They're long, but they're useful. And so at the beginning, they have, if you pull it up, they're available on the mass.gov website. They have the guidelines, and then there's commentary on the guidelines. And that's just a really helpful way to understand have a good overview of what the case law is and interpretation of the statute. But it's important for me to say that with a big caveat that they are intended to present governing case law, relevant court rules, orders, and policies, as well as accepted best practices. One thing also to note is for folks who do restraining order work as well as work under 258E's harassment orders, they're harassment order guidelines. So they came out at the same time. Hooray, but not relevant to what we're talking about today. So the updated guidelines interpreted the new statute, but it's important to note that the guidelines are not case law and they're not statute, right? They reference case law, but sometimes, as mentioned above, accepted best practices are not case law, not statute, not as persuasive. However, absent any case law, they are the best guidance we have at this point. And I think important to reference, especially when we're thinking about these bigger questions without many cases to go on. I feel like I forget myself and I should explain what case law is. So just really quickly. So when you apply for a restraining order, right, as you know, you could do it probate and family court, district court, some cases superior court, and that's a case, right? Then you get a judgment. If you don't agree with the judgment or the other side doesn't agree with the judgment, that person has the option to appeal the case and have the appeals court kind of review the work of the district court or the superior court or the probate and family court in their decision regarding the restraining order extension or non-extension. And the decisions that come out of the appeals court sometimes come out of the Supreme Judicial Court, which I'll spare you this whole background, they usually have a written opinion. Sometimes it's published, sometimes it's unpublished. We'll get to that. But either way, published opinions are considered the law. They're an interpretation of the law. Unpublished opinions are persuasive, but not so much the law. So that's what when I keep saying absent any case law, some of these questions in the statute, it's kind of unclear. Like, what do they mean by reduced sense of autonomy? Or what is a pattern, right? And so those are some questions that hopefully the appeals court will clarify for us through what I said, what I'm calling case law. So I'm sorry I didn't explain that earlier. Let me know if you have questions on that. All right, so here's what we have so far regarding the guidelines. So the guidelines, the first guideline, section 1A, it is the first place where you would see changes regarding the new statute. So the first thing I want to point out, in the commentary under the new definition of abuse in the guidelines, it says outright, a plaintiff must make a showing of 3 or 4 acts, which may include acts enumerated that we would. So 3 or more. So the statute doesn't say what a pattern is, how many acts constitute a pattern, but the guidelines say 3 or more acts. In saying that, they cite some criminal cases that define a pattern of conduct as 3+ acts. So it's not specifically defined in the statute, but the folks writing the guidelines, who are primarily folks who work for the court and judges, say that it's 3 or more acts. Could there be a case that come out that says a pattern could be 2 acts in certain circumstances? Potentially, but for now, this is what we have. And I don't know how likely that is. So, and then the other thing I would highlight too is, remember how before when I talked about the examples of coercive control in the statute, and I made a big point about included but not limited to. So what is awesome is that in the commentary, they say 3 or more acts, which may include the acts enumerated. So they're further acknowledging that the pattern does not have to be specifically one of or the behaviors to constitute the pattern does not have to be specifically the one stated in the statute. So yeah, so below here, below the commentary, I just show the language uses the statute a pattern, not 3 or more acts. So, but useful. Okay, so supported by some more useful guidance in the commentary. So again, when I talked about have a pattern, right? Going back here, pattern behavior intended to threaten, oops. Anyway, yeah, a pattern. Okay, doing great here. Why can I not go back? All right. A pattern of behavior intended to threaten, intimidate, harass, isolate, control. This is the pattern as a whole. The guidelines say that in order to have a pattern, each act must be intended to threaten, intimidate, harass, isolate, control, or compel. What impact does that have in practice? I guess we're still finding out, but it is important to think about how putting together a pattern, you're not looking at like the big picture necessarily. Each act kind of has to sit as each act constituting the pattern must have that intention to threaten, intimidate, or okay, so then the other language that is in the commentary is it says additionally, the totality of the conduct, must either cause that family or household member to reasonably fear physical harm or have a reduced sense of physical safety or have a reduced sense of autonomy. A reasonable fear of physical harm or reduced sense of physical safety is connected to fear of physical harm, but provides a lower threshold than fear of imminent serious physical harm. So that's important to note because I'm sure many, if not everyone in the audience know that the other definitions of abuse under the statutes are the old, well, no, I don't want to say old, the other definitions of abuse under the statute reference a fear of imminent serious physical harm. And here the guidelines are saying that a reasonable fear of physical harm, reduced sense of physical safety is a lower threshold. I mean, to me, it's pretty evidence from the text, but it's helpful to have them spell it out in the guidelines. Okay, reduced sense of autonomy. Remember before when I read it, I said, okay, we'll get back to this because like, what does that mean? So pretty text heavy slide. For that, I'm sorry. But the commentary to Rule 1A again speaks to this point. So it says that it's not defined by statute, but then it does cite some scholarly commentary saying, which I think is very helpful. And it's a good thing to think about how absent clarity under the law through case law, as discussed, scholarly commentary could be really useful. So in this case, it references how coercive control can be a micro-regulation of everyday behaviors, including controlling access to resources, isolating a partner from family and friends, stripping away a person's sense of self, and regulating daily activities, such as what a person wears, watches on TV, or does in their free time. The commentary also references that looks to other states. So this is another thing in advocacy. When the law in your state isn't super clear, you can look to other states and how their courts have interpreted this as potentially persuasive. So they say in, I think this is Hawaii, no. I could have sworn this was Hawaii, but maybe I'm getting it. But they talk about coercive control characterized as designed to make an individual dependent by isolating them from support, exploiting them, depriving them of independence, and regulating their everyday behavior. So I guess that's from the Washington statute. My next slide references Hawaii. Okay. So that's a little bit of clarity that the guidelines provide on how to interpret some of these questions. One other thing, this is like, we could do a whole training on this, but I'm not going to, is I'm sure folks might be familiar about this with the Supreme Court case from, oh, it was 2 years ago. I think it was last year, but fairly recent Supreme Court case, Aimee, which upheld a law barring an individual from possessing a firearm if they are the subject of a restraining order with a finding that the defendant poses a credible threat to physical safety of a protected person. So the thing that the guidelines bring up as a question with regard to Aimee and restraining order law is the gun surrender. And how does the gun surrender that we think of as almost automatic in restraining orders, how does that apply to cases where there's coercive control, where the restraining order was extended based on, or granted based on coercive control? So there are two places where the commentary kind of brings forth this question. And that's section 6, the commentary, and section 6.5. They basically say the same in each. So I'll just read one. But while the abuse predicated on physical assault, threats of violence, or sexual assault may clearly pose a credible threat, again, that's what the Supreme Court said you needed in order to take away somebody's gun in a restraining order case, is a credible threat. Certain abuse, i.e. some instances of coercive control, may not. The Rahimi court declined to address whether a finding of a credible threat to physical safety is required to order a firearm surrender. So essentially, the guidelines committee is saying this potentially could be a problem in interpreting federal law with respect to the firearm surrender, but maybe not. We don't know. So they say that when abusive behaviors may clearly present such a danger when a complaint is based solely on coercive control that causes a reduced sense of autonomy, the guidelines instruct the issuing judge should consider whether such behavior meets a similar threshold. So again, these are in the guidelines, but it's something to flag. Okay, case law or lack thereof. I think this might be one of my last slides. So there haven't been that many cases on coercive control in the past year. Certainly, I would just flag here, if you have one, or if you're working with somebody who has one that they think is wrongly decided and they're thinking about appealing their case, and it has to do with coercive control, we want to hear, reach out to us. We have a recent law grad working in our office on these issues next year. So we'd be really interested in working with you and hearing about it. All that being said, let's quickly go through what we have. So there was this one case from 2025, HMVMS. So again, remember I talked unpublished versus published. This was unpublished, but still persuasive. So in this case, it was a 209A extension. It was vacated based on lack of evidence that the plaintiff had reasonable fear of imminent serious physical harm. The thing I would point out is in the footnote, the opinion notes the definition of abuse didn't include coercive control when the plaintiff first applied for the 209A, but their conclusion would have been the same if it had. So I wish I wrote down the facts because now I'm getting my cases confused in my head, but it could be helpful to look to that case to think about whether or not your case might fit under the definition of coercive control. When I read the facts of this case, I certainly thought it did. And then there are a couple other cases where the coercive control is brought up by one of the litigants, and then the court decides the case on another grounds. And then, as I mentioned, if you're working with someone that you think meets the standard, but has a restraining order denied, we want to hear from you. So reach out. We have a project to work on these cases, so definitely want to be of assistance as we can. Okay, then this is just my catch-all slide on other considerations because we don't have enough time for everything. So one thing I would note are mutual orders. So those are defined as cases where these both apply for restraining orders against each other, whether it's in the same court, different courts, same time, different time. If there are two ongoing restraining order cases being litigated between the parties where the plaintiff and the defendant switch. So they are also do another training on this one, but I won't. They are subject to a heightened legal standard as well as specific procedural requirements. Happy to go into those for folks that are interested. Reach out to me. I won't right now. But the thing to know is that some people I've spoken to in the field think that they're seeing more mutual orders, and they wonder if this is related to the coercive control statute. And I would just reiterate that there are heightened protections in these cases. And so should that come up, there are, look to the guidelines, look to the cases, and give us a call. And again, this is added to the definition of abuse under 209A, meaning that it expands the standard for obtaining a restraining order, but it also expands what can constitute a violation when the face of the order requires the defendant not to abuse the plaintiff. We don't have any cases on kind of how that plays out, but it's a good reminder. Again, extension is a different standard, does not require new incident of abuse. This is very clearly stated in the statute, despite what opposing attorneys have often argued in my cases. And you must show that the extension of the order is necessary to protect the plaintiff from the likelihood of abuse. Again, we have a broader definition of what abuse means now, hooray. And so you want to incorporate this in other aspects of your advocacy. All right, now you're bored of hearing from me. I'm passing it over to Aimee, but thank you for bearing with me. I'm going to say it one more time. Reach out to us if you have a case that you think was wrongly decided based on coercive control.
Hi, everybody. It's nice to be here again this year talking about coercive control. Let me start with what I'm and my colleagues are seeing actually on the ground in the courts. Basically, the good news is that, progress is being made. The courts are more familiar with the idea of coercive control than they were a few years ago. And I do think the judges are often more open to hearing about coercive control. So that's good news. But the problem is, like, what happens is that survivors are describing real harm, but that doesn't necessarily sound what the courts would expect coercive control or domestic violence to sound like. And that is the core challenge with coercive control. Without the physical violence, it can come across as relationship conflict. And so what I'd like to focus on with folks today is how to take the information that you receive from your client at the intake or during the interview phase and help you prioritize or emphasize the facts that will help meet the definition. So basically, although there is more awareness, there's still a little confusion for what qualifies as coercive control, but more importantly, how to present it clearly. And the challenge with coercive control is that it's a little bit harder to explain without physical violence. So what we have been working on doing, the folks here at GBLS, as well as all the legal services attorneys here in Massachusetts, we all talk, believe it or not. So basically, yeah, what we've been trying to do is come up with some practical tips and sort of guidelines for what's been effective when we've been presenting 209As and all over Massachusetts. But for me, my focus is in the greater Boston area. So mostly within any area that's served by like the subways, basically. We do family court cases in Norfolk County, Suffolk County, and in Middlesex County. So my observations are from those district courts as well as the family courts in those areas. I would love to hear more from folks in other parts of the state and what they're hearing too. So much like what Anne was saying, like share your information with us because you all are actually incredibly helpful in that part of this law for the lawyers, since you have so much more direct contact with the survivors than we do. So basically, how do we make this clear for the courts? There's a few things that really matter here, and I'll break them down into 3 categories. The first being, sorry, I didn't say some practical tips. We're still there, yeah. So basically, we've got 3 main things. We've got the specificity. So here we want to make sure that we're being specific enough. So for example, you don't want to say he controls everything. Instead, you want to talk about, what happened, when, how often, and what the impact was on the survivor. And there's many different ways that you can sort of do this depending on the facts of your case. The next thing to think about, when we've talked a lot about this over the past 2 years, and Anne spoke about it as well, is patterns. And how many incidents do we really need to establish a pattern? I think that the more the better. With a minimum of 3 in my experience. And then, not just listing them, but also categorizing them so that you're seeing a couple of different examples of how coercive control is showing up in the relationship. Basically, like you could go either by timeline, you could go by categories of behavior. So maybe you're going to show a pattern of stalking-like behavior, followed by a pattern of let's say well, there's lots of different other things we'll get into here, but the last thing is organization. So you know this quite well. So many of our survivors come to us with pieces of a story, texts, memories, moments, but it doesn't have a real structure. And depending on how much sort of trauma therapy or help from advocates your survivor has had access to, it can vary pretty considerably. So you can help them by helping them organize their timeline. I've done things like, take all of their communications and look at them and help them establish what I see as like patterns unfolding. But also the absence of things. Our survivors are often not given access to things like financial, so that they can sort of take care of themselves or their children. They're often isolated, so they're not given access to friends or family. So it's sometimes important to not just talk about the things that are being done to the person, but also the absence of things in their life. And then the most challenging part for the attorneys and for advocates and litigants is how to connect the evidence to the story. Because at the end of the day, it's much easier for a judge to do what you want, which is to grant, a restraining order or an extension to a restraining order, if you tell the story in a way that makes sense to them. And so storytelling is something that's not talked about as much as I think it should be when you're explaining what's happened to you. And sometimes that means taking some creativity with your facts, because you have to sometimes acknowledge that what has happened to your client is just so awful that it doesn't sound believable. And in certain circumstances, you might have to choose from a lot of different types of abuse. And, thinking about which one seems the most believable might be an important part of placing your priority on that fact in your case. And then lastly, trying to figure out what evidence outside of your client's testimony, because remember, your client's testimony is equally important evidence than a document, right? But the documents help, because sometimes a client's credibility might not come across in court the same way as it would if it weren't in such an adversarial atmosphere. And it's important to be able to sort of help explain that to the court and to the judge. So some things that help show a pattern that I've used a lot over the past couple of years are things that we would typically use as evidence in the olden days too. So, things like texts, emails, photos, call logs are a good one because you can show the frequency of the contacts there. So that's a good way to show a pattern of calls. You can also show how long different, phone calls took place, if that helps to prove what you're trying to prove. And the other thing is to show the impact that this has had on the survivor, whether that is, did their HR department call them in for a meeting because, something happened at reception that, reflected poorly on you because your abuser showed up at your work or called the number so many times. So that might be a place where you can get evidence either in the form of a witness or perhaps some sort of other evidence that could show what had happened. Next slide. Okay, so this is like a little controversial because I feel like everyone's being inundated with AI everything right now. But I wanted to bring it up briefly because it is coming up more and more, and I want advocates to feel confident and comfortable using it if it helps them, but also kind of give you some ideas of where I've seen it become a little bit dangerous for our survivors or for ourselves or for lawyers. First, and this is important to say, is that, AI is not a replacement for a lawyer. And I understand that sometimes our clients or our survivors are stuck and they don't have any legal advocacy and they can't get a lawyer and they're in a pickle. And it might be really tempting to use, AI to draft motions and such. But I caution you against that if possible, because it is just not that accurate. It can give incorrect information, it can give incomplete information or misleading legal information. I've been using AI a lot since it first came out and became available here at GBLS. We have a specific version of it that has more security protections in place so that when we put anything in there, it's not going into ChatGPT's brain and, informing them. That said, do we all really totally understand how it works? Probably not. So this slide is a great slide for just giving you some information on how to be a little bit more cautious. There was a case that came out earlier, I can't remember if it was the end of 2025 or 2026, that had an example that you see right there in the center of that slide where a litigant who was represented by an attorney cut and pasted the emails between her and her attorney or his attorney into Chat GPT or a similar AI platform. And the courts, got brought to the court to decide whether or not the privilege is lost when a litigant uploaded the emails to a third party platform. And so many of you that work with attorneys know that, even if we have an advocate in on a meeting with a litigant, that destroys the attorney-client privilege. And that is a very, very unique and special right that our clients have. So it's important to us, as well as it's required by us under the rules of professional conduct to follow these rules. And so, advocates, depending on your level of not education, but your letters after your name have different rules that you are sort of moved by in the world, confidentiality, which is different, but they overlap in a lot of ways too. So yes, I would be cautious about using it in some of those ways. And then the other thing, and this is me personally, but I just feel as if the AI it has this sort of like built-in sort of way of doing things where it sort of flattens everything and to both sides, so it can kind of make it seem more, again, like relationship conflict, which is what we're trying to avoid with the coercive control statutes. So, if we're using it as advocates or attorneys, we have to just really think about how that context can really matter and not to rely on it, because let's be honest, advocates are some of the most important first line responders to our survivors, and you have experience that is real and important. And I would hate for anybody to rely on a computer when they already have the skills that are superior to what we can get on AI. There are lots of contexts that can help organizations in preparation for courts, but I just want to reinforce the lawyering for lawyers. But that said, there are some like really exciting ways we can go to. Oh, good. Next slide. Yeah, we got it. There are some really exciting ways that you can use it and experiment with it. And I would encourage everybody to, play around with it a little bit if you can, because I think then you'll better understand how to use it responsibly and share that information with your the folks you're working with. So yeah, AI can help survivors organize their story. It can help them with timelines and patterns of behavior. It can also help with documenting incidents. It can be useful also for preparing for court and helping you with lots of parts of what you're going to say. If you're not represented, it can help you prepare your oral argument for your restraining order. And that could be something you could help with if a client was, you were helping them and maybe you helped them draft the affidavit. You could help prepare them for their own hearing if they don't have a lawyer by using AI. And that might be a great way for you to help even draft an affidavit. Again, not the law part, but the facts part. It can also really help survivors that are really overwhelmed and unsure of where to start. Those folks that don't necessarily qualify for legal services because they're just slightly above the federal poverty line can feel really ignored and lost in, the current state of attorneys and availability in Massachusetts. So I do understand that, they're going to use it and that might be the only way that they can. Lastly, I just wanted to mention that last but there, which is that it can be a tool for reflection and validation for our survivors too. When we were preparing for this training, Carmen actually shared a lot of what she has seen with her the folks that she works with within the DV movement and such. So I was intrigued to learn more about that. So if anybody is using it for a way that is been helpful and you feel like it's a great thing, I would love to hear more about that. Alrighty, next slide. Okay, so those of you who were here last year may remember we did some hypotheticals, which I thought was a lot of fun because it gives us an opportunity to practice everything that you've learned today, as well as what you've already known before coming to this training, and put it into practice. So I did them a little differently this year so that we can kind of go through more slowly. And I'm also aware that there's limited time left, and I have 3, but I can wrap up whenever we're short on time. Alrighty, so the first one here is about Sam. So Sam's partner requires full access to her phone and her accounts, reviews the messages daily, and threatens to send private information to her employer if she resists. And so I want you to think about using this hypothetical. What makes this coercive control? If it does. And what evidence would you use to help support her story? Next slide. So here we have a pattern, right? So we've got monitoring, we've got threats, and then we've got workplace impact. And so our job is to sort of take these and marry them all together into a story that makes sense, and then decide what evidence you need in addition to that, if any. So I've given a few ideas of what I think could potentially be helpful evidence here under this fact pattern. So screenshots of the demands, if they exist, or the threats is very, very powerful and persuasive, as well as any other messages that indicate some of what she was talking about in her complaint or in her original affidavit. And then work emails for consequences. So here we have the example that I referenced in the beginning, which is how can we prove that her job has been disrupted by whatever behavior the abuser has engaged in. So we can show that perhaps maybe she got written up, or maybe she was unable to concentrate on work after the situation and had to leave early, so she lost income. Maybe the stress from all of this, especially the fact that she feels like she might lose her job, is so much that she's losing her hair, losing weight, her periods have stopped because of stress. There are so many physical ways that domestic violence can manifest, and I think that if you can talk about that at the hearing, it can really help with credibility, and it can also really help the judge understand how serious these are. It can also sometimes indicate that your client has, issues with her mental health, which is something we deal with a lot in the work that I do. So if that is something that might potentially be the case, it's important that you talk about that with your client first and discuss whether or not that makes sense to bring up. All righty, next slide. All right, so this is Jordan. So Jordan's partner controls transportation, taking their keys and refusing rides unless Jordan complies, leading to missed work. So here's another one that's affecting work. There's a little theme today. So basically, what is the pattern here? We're trying to figure out how do we connect these different things, or if they're not connected, perhaps we've got 2 separate arguments talking about them in categories so that we can establish sort of multiple examples and patterns. Next slide. So here we have the control of movement. So it's a little bit different from the first hypothetical, but we also still have the job impact. So here we have some similar ideas for evidence, the text about the rides or the conditions. Again, attendance records or write-ups, messages either by email or text that talk about keys or access. You want to look out for whether there is a connection to job harm, because if there isn't, that might not be the best factor to bring up. You might also consider whether it's appropriate to call another witness, right? What if the person who works at the reception desk at her office was the one that, was the one that received calls or harassing anything? You might want to consider having them come to court with the survivor so that they can testify about what they saw with, firsthand themselves. You also want to watch out for testimony without any backup, because if you don't have any kind of corroborating evidence, that just means that you're going to want to elicit a little bit more sort of foundational facts about the job. So maybe, what do you do for work? How long have you worked there? Have you received positive, performance reviews? Did that ever change? Something like that, so that you can show that, this happened as a result of the behaviors. Next slide. How are we doing for time, Anne? I have one more, but I think I'm moving along pretty quickly okay, great. All right, so this is our last one. This one is Jamie, and Jamie's partner sends constant check-ins and escalates if Jamie doesn't respond right away. And so again, Jamie feels constantly monitored. Could this seem pretty harmless at first? Absolutely. I can't tell you how many times I've seen a judge say, well, why didn't they just block them? Not understanding how simplistic that is of a way to look at the situation. The other question is, what here could show a pattern? And so the hypothetical references constant check-ins. So I would want to inquire about how their partner's checking in. Is it over text, email, phone, in order to be able to sort of determine where we can get our strongest evidence. Next slide. Okay, so again, we've got the volume. So this is a good, pattern. And then this one has escalation and loss of autonomy. So the loss of autonomy part is pretty tough for folks to use, because the word autonomy is, by definition, similar to freedom, but different. So a lot of us are curious about how this will sort of pan out, and we're dying for a case to go up on appeal that talks about loss of autonomy, because right now, trying to determine a good definition for autonomy is a little bit tricky, especially given the changes in Roe v. Wade and Casey, and all the changes in abortion law, because that uses autonomy too. And other things under like the 14th Amendment are also using that word. So the intellectuals are, trying to figure out how that works. But really, until we have a case analyze it here in Massachusetts, it's kind of undefined in a meaningful way when it comes to coercive control, in my opinion. But that doesn't mean you ignore it. I think that a big part of what I've been doing is, whenever there's a sort of like undiscovered area, I like to try to really talk about it in my case, whether it's when I'm at the oral argument part, or in my if I do like a memo in support of a permanent order and there's law in there, I try to really emphasize some of these things. I think an easy way to look at that part right now is a loss of freedom. And so describing how your client hasn't had any sort of freedom to be themselves and do their own things, and be separate person from their abuser because of the abuse, can be very powerful, even if you're not using the word autonomy, but describing the behavior and naming it coercive control. I think that's a part of the law that we could really push and utilize as it goes, on and on in our cases. So let's see, anything here? Yeah, so there helpful evidence. Look for escalating tone. I feel like I frequently overuse the escalating part of things when I'm going for a restraining order, but it always is so helpful to describe why now. Why now? If you can say that it's getting worse, it's getting more frequent, it's escalating, that can really show the judge that you're scared, and the fear is so important based on our statute. But being able to show fear, in a human being in a court setting is challenging. So yeah, some of the things to look out for with your clients are, they might feel it, right? But you look at their text messages and there's just few messages and they don't seem like they're enough to have made the client feel as unsafe as they did. Sometimes that means that, they've got more trauma and they're just like very sensitive. Other times it means that you just have to kind of dig a little deeper and ask them more questions and learn more about their life. Because that sense of frequency really is required when we're talking about establishing a pattern. Alrighty, next slide. So just to wrap up, you know what your role is. You all are probably more familiar with it than I am. But basically your role can be to help the survivors show the pattern clearly, simply, and in a way that the court can understand. But as we kind of move into I guess, is it technically year 2 of the statute being updated? It would be really helpful to pay attention to and share information about how you are moving from he said, she said to establishing a pattern, as well as collecting stories and evidence from folks that show how the judge has responded to different types of evidence and different patterns so that we can collaborate in that regard. How advocates can help the survivors organize their evidence clearly. Is it going to be like a binder? Is it going to be tabbed? Is it going to be, an accordion folder? There's so many ways to help them just so that they can get their hands on the right documents quickly. And then lastly, what should we be cautious about bringing into court? Or sending your client into court. I think a few things that self-represented litigants and maybe non-lawyers might not totally understand, but be tempted to use are records that are confidential or complicated, right? So there's very sort of special ways that attorneys typically deal with more sensitive documents. I'm thinking about things that have social security numbers on them, medical records, therapy records, emails between people that are in a privileged relationship. There's so many ways that you could accidentally or client could accidentally sort of share information on the public record and then wish she hadn't or he hadn't. And then lastly, so many survivors are sort of showing up with a lot of documents and a lot of papers, but they're not very well organized. And so when they're actually up there speaking to the judge, they can't tell their story in a way that makes linear sense because the papers are disorganized and their story will likely be disjointed if they haven't had good coaching from you or from somebody to kind of prioritize which facts and to tell their story in a way that's sort of short and sweet, but talks about the most important factors. So these are some things to think about. If you're anything like me, you'll print out these slides and keep them handy in like a 3-ring binder and look at them every once in a while. The parts of the law that Anne highlighted in those early slides are really, really good. So I would encourage you all to use them and like interact with them over the course of the next year. I think that was my last slide, but maybe one more. Nope, perfect. Thank you, everyone.
Thank you, Aimee and Anne, for walking us through those protections that the coercive control law provides survivors and equips allies and advocates with to protect them. So speaking a bit about the law and how it was passed, it's because of allies, advocates, and survivors like those on this call. There were many that came together to form a statewide grassroots coalition that goes by the name of TRAC, which stands for Together Rising Above Coercion. It is committed to passing protections that help survivors of domestic abuse. So that is our only goal. We do get involved in trainings, but we do not get involved in court cases. We leave that to the experts like you heard today. We have brought together lawmakers, advocates, and survivors to expose the long-term systemic dangers of coercive control. And after hearing from survivors and hearing stories and working together and getting the right language, the bill was fast-tracked on Beacon Hill. It was originally filed in January of 2023. It made it out of the House and the Senate in record time. Within 18 months, we saw passage of the bill, but that was only because of a concerted statewide effort. So it was also, as Anne had mentioned, it was combined with what was then a standalone revenge porn bill that was going through the process on Beacon Hill, and we identified that revenge porn is actually a form of coercive control, hence the name, an act to prevent abuse and exploitation, because revenge porn is exploitation. So combining those two bills allowed also to get greater support and faster passage. So that brought further attention from the media and more survivors. But again, I was but one of many invested in seeing this bill pass. And so I take no credit. This was a group effort. So while it was my story that may have initially broke some of this, of what was going on behind the scenes, as a member of TRAC, I can assure you that my voice and experience is just one of thousands throughout the Commonwealth. So we are grateful to each of you who are on the front lines supporting those who have broken their silence and speaking about what goes on behind their closed doors. We're grateful to have had this opportunity to speak about this bill today and to walk you through the steps that can be taken. Aimee gave some great advice about how to set this up for the courts, because what we are hearing is a lot of people are relying on this bill now, but organizing the information and having the evidence is critical. So we know success does not end with the passage of the coercive control law. We rely on agencies like MOVA and Greater Boston Legal Services and Mass Law Reform Institute to continue to support survivors, but also to train those advocates and allies and agencies who are representing survivors. So the work is vital. Those of you who are on the front lines doing this, you have my absolute admiration and support. This is hard work that you are doing. I lived through it, one experience. You are dealing with it day after day, and I just applaud and thank each of you for helping those who can't speak for themselves for whatever reason. So the good news, progress is being made. If we can flip to the last slide, please. We don't have the numbers in front of us. We want you to stay in touch, but data does show that of women who seek assistance for abuse, about 60 to 80% of us have experienced coercive control. And coercive control significantly increases the risk of an abuser killing their victim when they leave. So up to 90% of female coercive control victims experience post-separation abuse. So that is just the first step for us, is getting people out of bad situations. But then we have to make sure that we use this law to protect them once they are out. So again, in Massachusetts, we're making progress to address this. On behalf of survivors everywhere, I want to thank you for joining us today, because working together, we can and we will rise above coercion. So thank you so much.
Thank you so much to our presenters. Carmen, thank you for sharing your story and for your advocacy.
Do you mind if I say one thing before we wrap up?
Absolutely.
One thing I really love, I've been trying to use a different term to describe revenge porn. So I just wanted to throw that out there as a word, because revenge porn sort of implies a victim has done something to deserve this. And I would rather we focus on the perpetrator's wrongdoing. Some alternative terms you can use instead are non-consensual intimate imagery or image-based sexual abuse. I wanted to just throw that out there, because the revenge porn terminology is something I've recently started to hate. And so I've come up with some ways to describe it in a way that I think is more survivor friendly. And then other thing I wanted to say is that I love when folks reach out to me by email, but because I'm a full-time legal services attorney here, I can't always speak directly to survivors. If you're an advocate and you want to reach out because you think that there's some work we could do together to help your client, I would be open to that, but I would prefer that your survivors don't reach out directly to me so that I can help out the best. And then the other thing is, when somebody already has a lawyer, I'm not allowed to speak with them. But if their lawyer would like to, reach out to me to talk about, ways to work with the coercive control statute in a more helpful or persuasive way, and the same goes for advocates, like, I love doing that, and I would be happy to collaborate. Thank you.
Aimee, I see there's a question asking you to say your term again. And I would
Okay,
just-
so
yeah.
yeah, there's two that I like. One is called non-consensual intimate imagery or image-based sexual abuse. And there might be others, so look for them, but look for where, and I feel like we should do this a lot more than we do, but look for terms that really like place the blame on the person that's doing the harm rather than the person who's on the receiving end of the harm.
Aimee, and there's also a question somebody has asked, who can they contact for legal representation for coercive control?
So it really depends on the type of legal issue they have and if they are low income or if they have, more available, access to financial resources. At Greater Boston Legal Services, where I work, we have 9 different legal departments. And I know from my experience that survivors frequently need, lots of different types of legal help. So the best way to reach out as a first line for a client directly would be the Greater Boston Legal Services general line, which I can look up real quickly, or Anne might know by heart. On the other hand, if you are an advocate and you want to you've got something that's like an emergency and you want to kind of like jump the line, I can't guarantee anything, but if you came to this training and you reach out to me through my email, I can do what I can to help facilitate a warm referral. If that is the case, be gentle because I have such a busy litigation schedule, so I might not be able to respond right away. It might take me a week or two if it's not an emergency. If it is, make it clear on the subject line.
And I would just like to add that Jamie Sabino added in the chat, Mass
good.
Legal Resource Finder is a really good option. I just put a link to it as well.
Excellent. Any
Thank
other
you all
questions?
again so much. I think we have a few minutes if there's additional questions. I think when I send the email with the slide deck after this presentation, I'm happy to include the Mass Law Reform link. I think it had not gone to the entire chat, so I'll make sure and include that in the email. And if anyone has any questions, we'll just stay on for another minute. In the meantime, I just want to thank our ASL interpreters and cart provider for joining us today. And just thank you all again for taking the time to join us as part of Victim Rights Month, whether you're a provider, ally, or joining us with lived experience. We appreciate all you do to uplift victim rights and services in the Commonwealth. And MOVA will be offering a series of webinars throughout the rest of April in honor of Victim Rights Month. We hope that you'll join us. And I see that we don't have any questions coming in.
Definitely stay in touch. We want to hear from you about what you're seeing with this new law. And thank you so much for having us, MOVA. We really appreciate all the work you guys do helping survivors and sending folks our way and vice versa. So thank you for hosting this.
Thank you. We know
everyone.
you are so busy helping survivors every day, and so taking the time to share your expertise is just so wonderful. And so thank you for your time. I'll just note we did drop in the chat MOVA's training webpage, which has access to register for the other webinars the rest of the month. And I don't see any questions coming in. Lots of hearts and appreciation. So I think with no questions, we'll go ahead and end the webinar for today. And thank you everyone for joining us. Thank you again.
Thank you.
Thank you all.
Bye.
Bye.
Bye-bye.